Okay. So, good evening, everybody, and welcome to this Brennan Center event at NYU Law School. My name is Faiza Patel. I'm one of the co-directors of the organization's Liberty and National Security Program, and it's my great pleasure to welcome you today to this event on the Constitution versus Trump, Challenges to the Rule of Law. Our conversation couldn't be more timely. We're now in the second spring of Donald Trump's presidency, and his pursuit of xenophobic and retrograde policies has set off a wave of litigation, which is likely to shape the legal parameters of American society in fundamental ways. When I think back to the campaign, I remember that there was a school of thought that said that in the unlikely event that Trump got elected, that courts, which are normally very deferential to executive power, would be more skeptical of Trump because of the way that he had been through the campaign and the views that he had expressed. And I think to some extent, we've seen that that's the case. And litigators have won significant victories in the challenges to the Muslim ban, to transgender troops, et cetera. Although, of course, in many of these cases, the final word is yet to come as we wait for the Supreme Court to weigh in. But cases that don't involve individual rights, but do take aim at presidential ethics, such as challenges under the Emoluments Clause, for example, have been a heavier lift and have not gained the same kind of traction, really, that these cases have, although one has. But for the most part, we've had a more difficult time, I think, kind of enforcing things like, getting the president to release his tax returns or ensuring that he divests from his businesses and things of that nature. One last thing I just want to mention is that as we look at the issue of the Constitution versus Trump, we need to also think about it in the context of constitutional constraints on executive power more broadly, because some of the cases that we see are cases that have started previously under the Obama administration, for example, or sometimes we are looking at policies that are more extreme versions of things that have happened during previous administrations. So there is a broader frame to the issues that we're going to be looking at today. Now, to help us unpack these issues, we have a truly stellar panel of speakers and practitioners and experts. So to my right is Neal, the Saunders Professor of Law at Georgetown. He was the acting Solicitor General under President Obama, and he is arguing the Muslim ban case in front of the Supreme Court on April 25th. So I'm sure he has lots of interesting things to tell us. Elizabeth Wydra, to his right, is the president of the Constitutional Accountability Center. To her right is Jameel Jaffer, who is the executive director of the Knight Foundation, Institute for First Amendment. He is also bringing a really important case involving the president's blocking of people on Twitter. And to his right is Becca, who is the director and co-founder of the International Refugee Assistance Project, a crucial organization these days which has really stepped up both in terms of providing services and also representing refugee interests in litigation. She's also a lecturer at Yale Law School. And to guide us through what's going to be an interesting conversation, we have a most thoughtful moderator, Alex Heffner, host of Open Mind on PBS. And so please join me in welcoming our guests today.
Thank you all. It's really a privilege to be with this esteemed group, and it really is star-studded, and I hope you all can acknowledge that. Thank you all for being here. These are not just lawyers, but humanitarians, and I want to emphasize their contributions to public life in America, and several of them have also appeared on the air with me on my PBS program, so thank you for joining me, and you're welcome back soon, and those of you who haven't, come soon. I think about this question in terms of three areas in particular that Faiza alluded to. And the ACLU sent an email to its supporters identifying government oversight and accountability, immigrants' rights, and a host of other challenges that they've encountered. And I also wonder in this conversation if we can perhaps overcome or transcend or think differently, think beyond the question of are you an originalist or are you a living constitutionalist, the kind of traditional paradigm of discourse that these folks operate in, and imagine what is constitutionalism today, because originalism is not just the first 3 amendments, it's the 13th, 14th, 15th Amendment. That original document is holy, and I think this is an opportunity for this stellar panel to imagine what the jurisprudence of the future may be. With that, I wanted to lean first on Neal and Becca, specifically the case involving immigrants' rights, the travel ban, and I wanted to ask each of you who are involved in suits what the status is, and let our audience know, as Faiza alluded to, what's up. So Becca and Neal, please.
So Neal and I made an agreement before the panel that any question on law, I'd refer to him, and any question on reality, he would refer to me. So the reality of the lawsuits, there's been many iterations of the travel ban. We're now on the 3rd iteration. Neal will talk about that. I will simply say that the 3rd iteration split off the, too loud?
No, no.
Oh, you're just really engaged.
Yes.
Okay. I'm not used to that. The 3rd iteration split off the refugee ban from the travel ban. So IRAP, my organization, in partnership with a host of other organizations and law firms, brought a lawsuit saying that the refugee ban was illegal. We won that in the district court, and like 3 days ago, the 9th Circuit upheld the ruling of the district court. And we are hoping, and drooling might be more accurate, to get into some discovery on that, so we can see what all these people are actually thinking when they wrote all these lovely policies.
So Neal, the law?
Okay, so first of all, before I start in on the law, I just want to thank you all for putting this on. This is a really privilege to be here, and it's a privilege in 3 ways. One is obviously the day, April 4th, and Dr. King, his legacy on this day to talk about the rule of law for a man who really embodied it and changed the law in so many ways. I think it's a salient time. Second, the last time I was in this room was 7 years ago when I was acting Solicitor General. I confessed error in the Korematsu case and explained how the Solicitor General lied to the Supreme Court, and that's what led to the Japanese internment being upheld by the Supreme Court. I did it right from there. It was spring break, so very few people showed up, but this room has special significance for me. And then third is, this is the most extraordinary panel on the rule of law I've seen. And there's a lot of panels on this, trust me. But these are warriors for truth and the rule of law, and it's a privilege to be here with all of them. Okay, travel ban. April 25th, I'm going to argue it. What's the case about? Maybe the best way to tell you what the case is about, after I argued in the 9th Circuit, and this is weird because it was the first time a court of appeals, federal court of appeals argument was carried on live TV, not just in America, but across the globe, and on a bunch of different news networks and so on. And I came back home, and my 12-year-old son said, Dad, what's the case about? And so, I told him, well, there's the First Amendment. Congress shall make no law establishing a religion, and that applies to the entire government, not just to Congress, and that it also means that you can't establish a disfavored religion. And Donald Trump campaigned on this on December 7th, note the date, 2015. He called for, quote, Donald J. Trump calls for a complete and total shutdown of Muslim immigration to the United States. He likes to talk of himself in the third person. And then he later said, quote, I think Islam hates us, and stuff like that. So I said to my son, I said, the Constitution was built around the idea that you could come to our shores and be treated, fairly, regardless of who you prayed for. It didn't matter. Kind of went over a little bit with him. Then I started talking about the INA, the Immigration Naturalization Act. That was just way over his head. But just for all of you, there's 2 different arguments in the case. One is that Congress is basically in the driver's seat in our Constitution when it comes to immigration. In Article 1, Section 8, they have complete power over immigration, as the Supreme Court has said since 1824. And the president can't simply create effectively a line item veto and strike out different provisions whenever he doesn't want. It's Congress's job, not the president's. And so if the president wants Congress to change the rules, they've set all these rules about immigration, he's got to get legislation. And then second, specifically, There's a statute passed in 1965, a landmark statute, that says that basically you should have no nationality-based discrimination. Before that, you know, my parents, and I think maybe some others on the panel in the room, they came under the old quota system, in which different nations had different, you know, numbers of people and so on. Congress in 65 said, no way, that's evil, that's discriminatory. And this president, for the first time in our lifetime, since 65, since that landmark legislation passed contemporaneously with the Voting Rights Act, has said, no, I can do that. I can cherry pick certain countries that I don't like, so-called shithole countries, and say no immigration from them. That is very much in tension with the statute. So that's what the case legally is about. You know, I know that there's a lot of panelists, and so I'll just leave you with just a 1.5 minute final remark on this. You know, the day after my son said this to me, it actually became really crystal clear why I'm doing this. Because the next day was a column syndicated, every newspaper, in 200 newspapers, they each independently made the decision to run this column by Ann Coulter. And it's called, "Every Time I Try to Be Mad at Trump, the Media Pull Me Back." And this is how it begins. Hey, you know what might make more sense than banning laptops? How about banning Muslims? Bear with me here, I'm still working out the details. To preserve their judicial coup, this Monday, the Ninth Circuit sent out the geriatric ward to hear an appeal of the Hawaii judge's absurd ruling. At their ages, there's a good chance the judges will be dead by the time the Supreme Court overturns them. Not content to keep insulting the judges, like her, you know, de facto boss, the president, she goes on. Arguing against Trump's exercise of his constitutional and statutory powers was first-generation American Neal Katyal. There are plenty of 10th-generation America haters. You couldn't get one of them to argue we should end our country through mass immigration. And then it clicked to me. The idea that being a first-generation American would disqualify me from bringing this case when the country had given me so much. The idea that mass immigration would, quote, end this country instead of recognizing that's what the country was built on. When I read that, I thought about so many things. I thought about my parents coming here from another country just to be treated fairly. And that has been the American experience and its creed and its ideal. I thought about, you know, so many things that had happened along the way that, you know, obviously put that to test. But at the end of the day, I thought about our national motto, E pluribus unum, out of many one. That's what this case is about.
That's potent and compelling. Thank you, Neal. I think we all remember quite viscerally the spontaneous protests that emerge at airports around the country that can similarly testify to that emotion. I heard you saying, Becca, that there are particular people you're representing who've been offered scholarships in this country along the lines of what Neal just described, and who've been denied on the basis of their religion or immigration status. Can you elaborate on that? And then I want to ask Neal one follow-up on the law.
I mean, there are millions of people right now who are barred from entering this country under what I would call the Muslim ban and other people might call the travel ban. And that's, you know, the countries on the travel ban list are not countries from which a lot of people were getting tourist visas to begin with, right? Like, it's to get a tourist visa, you have to prove that you're not coming here with the intent to immigrate. And if you're coming from a dangerous place and you don't have a lot of money, it's really hard to convince the United States, even under previous presidencies, that if you got a visa here, you weren't going to try to stay and apply for asylum. What that means is that the majority of people from places like Yemen and Somalia and Sudan and Chad who are getting visas to do things like come here and study, or come here and teach, or come here and get emergency medical procedures. You know, we've had cases of Fulbrights who can't get in, which you would think that since their sponsor was the State Department, there might be something they could do to help them get a visa. Ostensibly, a waiver provision exists. In the text of the executive order, it says that they'll grant waivers in all these different cases. My understanding is that the internal policy is actually not to grant any waivers. So in Tehran, for example, they called a bunch of folks into the consulate who had valid visas, and they just rejected all of them en masse. Without considering anybody for a waiver. So there are literally people who are coming here to get life-saving surgery who now will die because of this travel ban.
Neal, let me just ask you quickly a follow-up on the law. You mentioned the principles of the Constitution in this country and some specific statute. What precedent?
The INA.
Right. What precedent will you rely on in terms of Supreme Court decisions, if you can preview at all your argument in terms of responding to the unitary executive? I mean, the likely argument being presented that this is within the president's prerogative and power.
Well, the case is pending, so I'm only going to stick to the public record. I'm not going to go beyond that.
Sure.
But it's always tough to bring a case against the president when he invokes national security. I mean, before 9/11, if you look back over the 200-year course of American history, there was only one time the Supreme Court said no to a president when he invoked national security in a time of threat, and that was the Steele seizure case in 1952. That's it. And we obviously have the Gitmo cases afterwards, but in general, it's really hard. I mean, I joke, I think you'll appreciate this at NYU, it's kind of like failing a class at Yale if you're the president. You really got to try to fail. But this president has done that. I mean, this president has done something unprecedented. There is no precedent about the Establishment Clause, restricting the president's powers over immigration, because no president has thought to do that. You have to go back to colonial Virginia in King George III to find a precedent. And fine, the Solicitor General can cite that. Great, good luck. So there isn't, I'm not going to be able to cite something to you, but I am going to cite to you the actual text of the Constitution. There shall be no laws respecting the establishment of religion.
Thank you. Faiza, you were mentioning to me, too, the extreme vetting. That idea is already being implemented, and it's alarming the extent to which we don't really have a transparent account of what's happening. Can you shed some light on that?
Twin sister of the Muslim ban in a way, as sort of a backdoor Muslim ban. So, a lot of the attention around Trump's attempts to keep Muslims out of the country has focused, rightly, on the ban because it's such a visceral thing to see. But as Becca knows as well, if you look at the refugee policies that are being put in place, those are also affecting primarily Muslims. Those are the populations who are being kept out of the country. And similarly, the United States has started doing something that they call extreme vetting. Now, if you remember back, this was, I think, the day before the first travel ban came down, and Donald Trump goes on TV, and he, obviously everything leaks out of this White House, so everybody knew what the ban was going to look like roughly. And he's asked, he's like, well, you have this list of countries on the ban, but they don't include the countries where the 9/11 attackers came from. Saudi Arabia is not on the list. Pakistan is not on the list. And he said, well, we're going to take care of that with extreme vetting. And basically, we don't quite know what extreme vetting is, but in essence, what's happening, and we've heard this from sort of around the world, is that U.S. consulates are clamping down very, very hard on applications for visas from around the country. They are doing something that they call extreme vetting, which, while not as definitive as the ban, in essence is choking off people coming from various parts of the world, and it extends far beyond the ban because it's not just the countries listed in the ban. It's something that's happening throughout the world, and it also has obviously a chilling effect, right? I mean, if you're not like the ban, if you're not welcome in the United States, there's a whole lot of people who just aren't even going to apply to come over here. And this is all being done along many of the same kinds of justifications that are being used for the ban. The idea that nationality is a proxy, if you will, for dangerousness. We've been trying very hard to get information out of the State Department about extreme vetting, which has not yet been forthcoming, but we're hopeful as we go into litigation this spring that will come forward.
Elizabeth and Jameel, I wanted to know if you would weigh in on this in terms of national security, the constitutionality of the administration's behavior, and we will transition from immigrants' rights to some other questions of speech, voting, and government oversight and accountability momentarily, but I want to give you guys a chance to weigh in on what's been said so far.
Yeah, thank you so much. My organization, the Constitutional Accountability Center, filed a friend of the court brief in this litigation on behalf of members of Congress. I think that They have a very specific point that is, as Neal mentioned, there is this statute that says that you cannot discriminate against people coming to this country on the basis of nationality because you want to disfavor someone, specifically discriminate against them. And that while it is true that the president does have substantial discretion, it has to be delegated from Congress under the immigration laws to the president. He has to act within that. And Congress has certainly not delegated the authority to discriminate in this fashion. But then the even broader issue of, as was mentioned, these important constitutional principles. And I'm so glad that you brought up the 14th Amendment, because you're absolutely right. These amendments that came through hard-fought, blood, sweat, and tears of people to change our Constitution, the 14th Amendment specifically is intended, if you look at the debates over the Due Process Clause, these sweeping guarantees of liberty in the 14th Amendment, they specifically wanted it to apply to people who were non-citizens. In the words of the drafters of the 14th Amendment, citizen or stranger, they were to have these important protections. And, we have a lot of dark moments in American history, but we also have some moments that we can be extremely proud of, and that is one of them. And so the folks that are coming together to fight for that, and I think the protests you mentioned at the airports, the legal actions we're seeing are really vindicating that 14th Amendment right, the First Amendment right to have a government that does not favor one religion over another. And, it's really making a reality the guarantees of the Constitution. Again, on this day, thinking of Dr. King, one of the things that really charted my career was Dr. King's observation that we have these wonderful constitutional principles, but for many people they're a promissory note that they can't cash. And so trying to make real those constitutional guarantees is exactly what this litigation is about. And we'll see when it comes to the Supreme Court whether or not the justices are going to be perhaps pressured by a lot of what we're seeing from Trump's tweets about, if there is some, national security incident, it's on these judges' heads. But justices and judges generally don't like that kind of threat coming from a political official, so I think that could very well work against him. I mean, his tweets generally haven't done very well in court, and I suspect this might be a case of that as well.
I would just suggest really quickly that we could even go so far as to reject the dichotomy between citizen and stranger.
Jameel.
Well, so I guess I'm not sure how much I have to add on
so
that
let's get to
Twitter
Twitter
at this point. Well, let me say one thing. Let me say one thing
okay.
about this. So this is to underscore something that I think Neal said earlier, which is that the courts are not accustomed to serving as checks on the executive's national security powers. That is not what American courts do. Over and over again, American courts have deferred to the executive when it comes to not just the exercise of national security power, but even the scope of national security power. The courts have deferred over and over again. So if we're going to see the courts act as a meaningful check on the Trump administration in the context we've been talking about, the courts are going to have to engage these questions very differently than they have in the past. There are probably 100 cases in which civil liberties, civil rights, human rights groups brought challenges to the Bush administration's national security policies, the Obama administration's national security policies. And as a result of those cases, there is a whole body of law that creates barriers to the courts addressing the merits of these national security policies: political question doctrine, standing doctrine, qualified immunity, state secrets. I mean, there are a million different hurdles that litigants have to get over in order to get courts to engage the merits of national security policy. So, I guess I'm hopeful that the courts will do what they have, declined to do many, many times in the past, and I'm glad that we have such capable lawyers handling the important cases that are before the courts right now. But I don't think anybody should be under the misimpression that that's going to be easy. You know, the courts are going to have to do something very different than they have in the past.
I agree with you. It's certainly not going to be easy, trust me. But I do think it's a little different. I mean, having been the person in the Obama administration defending a lot of those policies and winning those cases in court, I do think then we had the realistic argument that if Obama strayed, Congress would rein him in. I mean, you know, Obama could do almost nothing without Congress reacting in some way or the other. Here we've got the flip side. We've got Trump able to do anything, including bragging about shooting people in the street, and evidently nobody in Congress willing to do anything because his party controls it, and there's just a attention deficit disorder going on there. And because of that, I do think the federal courts do have a bigger role to play in our tripartite separation of powers than they did in past administrations. And then we saw this in Bush too. I mean, it was easier to win Guantanamo, frankly, because it was a Republican Congress and there was no chance that they were going to check the president. So it was up to the courts.
I mean, I feel like I'm not quite sure I fully agree with you over there, because I don't think we saw Congress checking Obama when he was asserting national security powers, particularly. I mean, the one incident I'm thinking...
because Neal won all the cases. Weren't you listening to that?
Right. I mean, you know, just leaving aside the courts, I mean, I think what Jameel says is really important, which is that, and as you said, Neal, there's like a history of judicial deference to executive power. Very rarely has Congress stepped in to constrain the executive's, you know, exercise of power as well. And I think one thing we have to be really cognizant of is that, you know, are the Trump cases an exception to a trajectory, or are they going to be perhaps, hopefully, setting a new baseline?
I don't want to go into too much back and forth here, but just I'd say that, you know, President Obama never did anything like what President Trump did. And one reason for that, A, he has a conscience, B, you know, he understands the law, but C was...
I feel like you could get down all the way to Z on that list of differences.
Yeah, but Congress is certainly one reason for that. And certainly, that, you know, when he did assert national security powers, Patriot Act and so on, Congress did have a lot to say.
So the question really is, are those circumstances going to weigh in the way the judges and the justices consider this case study? And that's where I'll go back to Jameel, because President Obama did not block, as far as we know, his POTUS handle did not block our fellow citizens. And Jameel and his colleagues are suing the administration for blocking critics who have not been able now to read President Trump's tweets because they were blocked. And I wondered if you could update us on the status. I know you and Katyal are working hard on this case.
Yeah, sure. So this is, as Alexander says, this is a First Amendment challenge to President Trump's practice of blocking critics on Twitter, which I think, you know, my first reaction to this problem was, this is a trivial thing, why care about it? But over time, I've come to care about it quite a lot, and we now have a case, a challenge, pending here in the Southern District over the constitutionality of that practice. I think it's, you know, the reason to think of that case in the same sphere as some of the other cases we're talking about, there are a few reasons. One is that this Twitter account is not just any Twitter account. It has become arguably the most important channel through which the Trump administration communicates with the public. President Trump announces government policy, he announces nominations to important government positions, he engages in international diplomacy with that Twitter account. Yeah, maybe there should be quotes around some of that. You know, it's an important, yeah, it's an important channel of communication from, you know, from this administration, and being blocked from that account means that it's harder for you to get access to that information, which is a big deal if you're a journalist, say. And it makes it impossible for you to participate meaningfully in the comment threads that are a kind of crucial conversation about the president's policies. And so just, you know, if you focus on Trump's Twitter account specifically, there are reasons to care, you know, there are reasons to care about this, but it's not just about Trump's Twitter account. It's also that public officials all over the country now communicate with their constituents through social media. That's the way public officials communicate with their constituents. And we want to make sure that there's a set of rules that ensures that public officials hear from their constituents and not just from the constituents they want to hear from. And then the other reason I care about this case is that I don't think about it solely through the lens of new digital technologies or through social media. I think of it in the same way as I think about sort of old school censorship, political censorship in more authoritarian societies. About a year ago, President Trump gave a speech in Warsaw, the public square, the main public square in Warsaw. And the Law and Justice Party, which is a nationalist party that is in charge in Poland these days, bussed in supporters, paid supporters, to come to the event and to cheer on President Trump and to shout his name before the speech and after the speech. And they, as is a custom or a practice in authoritarian societies, people who were going to dissent or disturb the peace were kept away from the square. And so the cameras didn't capture any dissent. The cameras captured only support for the president. And there was this kind of spectacle of political support for President Trump and for this nationalist party in Poland. There's a lot of criticism in the American press of this practice, and everybody said this smacks of authoritarianism. This is not the kind of thing an American president should be endorsing, let alone participating in. And everybody understood that right away. But that is what is going on President Trump's Twitter account every day. This is a digital version of that practice. And I think we should see this practice through that same lens. We should see this as a digital version of that practice that is common in authoritarian societies, and we should see this as yet another indication of our sort of trend in that direction. So that's another reason to care about it. But we argued this case just a few weeks ago before Judge Buchwald here in New York. I thought the hearing went well. We're waiting for a decision.
Apparently, the judge suggested that the president ought to mute accounts, right? As opposed to, that was one way to logistically
I think, right, so, I don't want to get into the details of how Twitter works. You're either on it or you're not on it. But, there's a difference between blocking and muting on Twitter. Blocking has much more draconian consequences than muting does. Muting means that the president doesn't hear you. Blocking means you can't participate in the forum that the president's Twitter account is.
Right, and I mean it's relevant because if this is the digital town hall, the anti-democratic forces in the country are conspiring against us every day when our representatives refuse to have town halls or only have teletown halls where they're listening to like those folks in Poland, calling up and saying, you're the best.
In this case, I mean, it is true that if the president wanted to make the case go away, he could make it go away very easily. But the president's position in this case is not just that his actions don't violate the First Amendment, but that the court lacks the power, even if his actions violate the First Amendment, the court lacks the power to order him to stop. And this is actually a theme that runs through all of the cases that we're talking about today. In a lot of these cases, in the travel ban case, in the emoluments case, in our Twitter challenge, in all these cases, the president is relying on this post-Civil War case, Mississippi versus Johnson, to argue that the court lacks the authority to enjoin the president. That it may be that the president is acting unconstitutionally, but the court can't do anything about it, which is a remarkable, it's a remarkable thing. And so when I didn't, 6 months ago, I was not using the word authoritarianism to describe any of this, but I have come to the conclusion that that is the best, that is the best description of the instinct at the bottom of many of these policies. And I think it's true for most of the things we've talked about so far.
And I bet most of the folks in this audience, regardless of age, do relate to the Twitter case. I mean, many of them probably have Twitter accounts. It's the first injection in our bloodstream, whether it's true or false, whether the tweet is true or false. And therefore, I think a lot of people are going to be following your case, which is a nice transition to Elizabeth and thinking about the emolument suit, which has not gotten enough traction as of yet, but just within the last couple of weeks, a new case has gone through the avenue of judicial process, which it hadn't, and I hope you would update all of us on your case.
Yeah, absolutely. Thank you. So there are 3 main emoluments cases that are working their way through the courts right now, and I'll go in order of sort of how far along they are. So there was a lawsuit filed here in New York that included some private hotel and restaurant owners who are suing for the president's taking of foreign benefits, like at his Trump properties, et cetera, and saying that as hotel owners, they are being harmed by having the competition go to Trump's properties to curry favor. Now this comes up, then the second lawsuit is filed by the state AGs of Maryland and DC with a fairly similar theory. They run convention centers, for example, and so they've argued that the Trump Hotel takes competition away from them, these public buildings. And then our lawsuit, we sued the president for violation of the Foreign Emoluments Clause on behalf of 200 members of Congress. This is the largest number of members of Congress to ever come together to sue a sitting president. So it's an appropriately historic lawsuit for an appropriately historic thumbing of the nose at the Constitution. So for all of you who don't know the Emoluments Clause by heart, which I can't imagine is possibly anyone here, you know, we've all gotten an education in a lot of these somewhat obscure parts of the Constitution, and certainly the Emoluments Clauses are one of them. The Foreign Emoluments Clause is a ban on federal officials, leaders, accepting gifts, profits of any kind whatsoever from an agent of a foreign government. Now, this might seem like an obscure clause to us now, but at the time of the founding, it was an incredibly important anti-corruption measure that was written into the Constitution. And it's interesting when you look at the debates over the drafting of the Constitution, corruption was a concern that was raised on more days than pretty much any other part of the Constitution. There was a deep concern about foreign, in particular, foreign powers having an influence over the US government. And you can see why they would think that. They were a fledgling nation at the time. It would have been very easy for a foreign power to, get sway over the president or the leader of the Congress. And so they were very concerned about this. And if you read some of the Federalist Papers when they're talking about exactly what they were concerned about, it seems as if they somehow knew Donald Trump was coming. So the Emoluments Clause has been in effect since the founding, and it has come up from time to time, usually in much more innocuous, kind of colorful ways. The initial example of a foreign emolument was this jewel-encrusted snuff box portrait of the King of France that was given to Benjamin Franklin and some other diplomats. And the idea was, if you go to Congress, because the Emoluments Clause, in addition to banning foreign profits from flowing to a federal official from an agent of a foreign government, it says if you go to Congress to get consent for it, that's fine. So there have been times throughout history where we've had instances where someone got a horse, someone got a sword from the Sultan of Brunei, and they went to Congress, and either it was okay or it wasn't, and in which case it generally went to the Interior Department. Trump has not done this. He hasn't gone to Congress, even though his party controls Congress, and has not asked for consent to continue his foreign business dealings. He's basically said, I don't have to follow that part of the Constitution. But it's incredibly important that he does, not just so we can see his tax returns, although of course, if we get to discovery, we will definitely be asking for those. But it's really a structural part of the Constitution that ensures that Congress plays its oversight role over the executive, because in order to get consent from Congress, there has to be transparency, there has to be disclosure of what emoluments the president or any particular official wants to accept. So the corruption concerns expressed by the founders are alleviated when there is a laying bare of the foreign transaction and a determination whether or not it raises these corruption concerns or not. Maybe it doesn't. Maybe it does. And here there is very substantial concern on behalf of these 200 members of Congress that President Trump has not gone to them, has not laid bare his foreign business transactions. And so we are left with the question every single day and with every single policy, is he acting in the best interest of the American people, or when he's engaging in foreign policy, is he looking to line his own pockets? So we are asking for the courts to do its job in this three-branch oversight system and require Trump to do what the Constitution says and to go to Congress to get their consent. And if he doesn't want to follow through with the letter of the Constitution, then he has to stop accepting these foreign emoluments, foreign payments, whether it's at his hotel, whether it's trademarks, whether it's rent coming from foreign governments at his properties. The list goes on and on and on, and that's only the tip of the iceberg that we know about from the excellent reporting that's been going on. Who knows how many other foreign business dealings he has, because he has not followed the Constitution and gone to Congress to get their consent. So our lawsuit is in the District of Columbia federal courts. We have argument on June 7th, and we are hopeful because while the court here in New York dismissed the suit by the private hoteliers and Crew, a public interest organization that filed the lawsuit and was also a plaintiff. That case will be on appeal, though, for sure. The court in the Maryland and D.C. case did find that they could go forward, at least in part, with respect to the Trump Hotel in D.C. So that's a very, what we think, an encouraging sign that the courts are willing to say, yes, the courts do have jurisdiction here. The courts can issue an injunction if we find that it's appropriate, and that you can go forward and look into this. So we are hopeful that because Congress has a role that's actually written into the Constitution in terms of oversight on emoluments, that the court will let us go forward with our suit. And if it does, then we will look very closely into the many, many foreign dealings that the Trump business has. So it's an incredibly important case, and we are just delighted that the Constitutional Accountability Center can be part of it, because this is the essence of constitutional accountability.
Well, I think in all these instances, we've seen how the conduct of this administration is veered towards unconstitutionality.
Authoritarianism, I think, is what Jameel said.
You know, I remember asking Ken Roth that question early on in the administration, and he didn't want to go there yet, but I'm sure he would now. And it wouldn't be sufficient for him to separate himself from the business now, which he promised to do and never did. Because what about all of those business dealings subsequent to his election? And he was not in any way disbanded from the corporation and still knows what's going on there. So at this point, he really couldn't do anything besides full disclosure. The extent of disclosure is a claim made by the Treasury Department that he donated a certain sum of undisclosed money. Right, that's the
but that's even just from the hotel. So that's, you know, he's not giving back the Chinese trademarks. Sure. He's not, you know, any.
But I mean, that's the single piece of non-information, non-disclosure.
And we don't even really know exactly what's going on.
And I got an update this morning from Crew, too, which said that their second case, which represents, in addition to the 200 congresspeople, the attorneys general of Maryland and D.C. is moving forward as well. And it is on the same grounding that it is that the office prohibits him from accepting these foreign gifts. Collectively now, we can kind of connect the dots here. The Constitution is under attack by, you know, in some really basic ways. What is most concerning to you about this trend? And is it, you know, at this point, if not preventable, is it something that we can stop?
Was that too?
Neal, we haven't heard from you in a while.
Well,
You're trying to stop it, so let's
I
hear
mean,
from you.
I think the common theme you've been hearing is that President Trump is an unprecedented threat to the rule of law. I mean, in a way that is unlike anything in our lifetimes, unlike anything in a long, long time. And we need to use every tool in the toolbox to try and resist this. And one of the things I'm so excited to see is Elizabeth's Constitutional Accountability Center, because what they're doing is almost reversing the conservative playbook. For years it was liberals who didn't care about the text of the Constitution or the history of the Constitution, and it was conservatives who were all strict and into that. And now it's completely flipped. Trump doesn't care a whit about the Constitution, and it's people like Elizabeth who are standing up and saying, oh, you know those obscure clauses that no president ever thought to violate for 200 years? You're violating them. And it's extraordinary to see, or Jameel's lawsuit about the First Amendment, which was generally been used over the last 10 years to protect corporations, now being used in this innovative, really smart way on something that, when I first read about the lawsuit, I was like, do we really care? I mean, Twitter is for rock stars and stuff. But he's absolutely 100% right in this litigation, and we supported him in an amicus brief because of that. I mean, it's so right. So we can be pessimistic about Trump. We should be, but I think we should be optimistic about folks like this. Right.
So that comes back to the prompt at the beginning. This idea that there is a certain textual, common sense, consensus, textualism or originalism that ought to be applied in any number of these situations. And for those who are so caught in their mold of partisan fiber, can you revive the idea of a strict constructionist ruling in a way that is consistent with something that isn't a constitutional principle and not a Trumpian or Trumpist principle?
Just one thing I'd say on that, and then others I know have lots to say, but is that I am heartened by the fact that there are a bunch of responsible conservatives who are standing up against Trump on the rule of law in saying the Constitution, either strict construction and any construction, he's violating it. I mean, we have briefs filed by Evan McMullen and Max Boot and, Michael Steele, who was the head of the RNC, all saying the travel ban's unconstitutional and illegal. A whole range of people. So I do think, while the folks in Congress are, effectively spineless against Trump, I don't think that's true about the conservative movement more generally.
Yeah, I think that's a really great point that, we have seen in the courts, even if not in the political sphere, folks from all sides of the ideological spectrum coming forth. We, in our emollients case, had a great brief from national security folks who worked in both Republican and Democratic administrations, from Secretary Kerry, Secretary Albright, to Chuck Hagel, noting that this is, however you feel about Trump, a national security problem when you have improper influences. And I think that that's something that, is important in all of these cases, these ideas that there are fundamental basic principles at stake, whether it's, the idea that you don't, when people are coming here. I think the refugee part of the Muslim ban is so heartrending because, you have people coming here as refugees and we're discriminating against them on the basis of religion. It's just so un-American in terms of what we should be as a country, putting aside the times when we have failed those promises, but what we should be as a country. The idea that you can shut down a town hall, which is, thinking about kind of quintessential founding ideals of free speech and debate, that's just crazy. But I think right now, we've talked a lot about constitutional crises, like on, all the pundits talk about it. And right now, we're not there because the courts are doing their jobs. You have the courts putting a stop to the Muslim ban. We hopefully will have the courts step in and play their oversight role in the emoluments cases. So right now, the Constitution is working as it's supposed to, where we have limits placed on Trump's unlawful actions by the courts. I think Congress is for sure falling down on its constitutional job, but I think right now there is cause for hope.
So can I just add one thing to that? So I agree with all of that. one problem you get when you have all lawyers on a panel is that we talk about, we evaluate how good or bad things are by looking first to court cases and what the courts are likely to do in those cases. But you can imagine that, imagine a world in which we all win the cases that we've just described. And obviously that'd be a great thing. A lot of these awful policies would be rolled back. But I'm not sure that that would be a solution to, or a complete solution to, the problem that we face right now. I mean, if you just think about Trump's daily verbal assaults on the institutions that are most important to our democracy, right? His daily verbal assaults on the press, or on the Department of Justice, or on the courts. Over time, I think he has already eroded public confidence in those institutions. And not just in those institutions, but even in, I think he's eroded our ability to have conversations across political divides. And there's no court case that's going to save us from that. No litigation victory is going to restore that trust, restore public confidence in those institutions. And I don't know what the solution is to that. I don't know what that looks like, but it's not a solution you're going to find in the courts, or that's going to come from litigators. It's got to be a more sort of political or cultural response. It's worth thinking about how much the law can do, and what kinds of tools we need in places where the law can't help.
Faiza.
Yeah, and just to build a little bit on what Jameel is saying too, I mean, there are human costs to these policies which are occurring every day, right? So, the Muslim ban has been rejected by all these courts, but the Supreme Court lifted the injunction on the ban, right? So the ban is in effect. We have, families over here who aren't able to bring their loved ones over, right? I mean, there are human beings who are today feeling the impact of the ban. Similarly, in the refugee situation, right? You have individuals who are feeling the effect of this. You have, minority populations feeling the effects of a president who demonizes them on a regular basis. So there's the harm to the institutions, but then there's the harm to the people as well. And again, litigation can stop that in narrow areas, but I don't know that it really takes care of the harm. And when you're looking at it, you got to think about where you sit when you talk about whether or not our institutions are holding up. Because if you're the person whose daughter is stuck in Syria and can't come and reunite with her family, you're not finding that the courts are doing that well after all.
So I agree with all of that. I mean, the law is only part of a solution. It's the only thing I know in my toolkit. I mean, I'm not going to run for office or something and change the world that way. Nobody will vote for me. But I don't think we should underestimate the power of litigation. I mean, you think about Brown versus Board of Education is a case about schools, but it's actually a case that transforms society, or Bergefell, is another example. I think that wins in these cases do have radiating effects far beyond the case at hand, and do call into question what Trump is doing. And it starts to build support for a movement, for an idea that, hey, we can be Republicans or Democrats, it doesn't matter. At the end of the day, we believe in the Constitution of the United States.
Yeah, and I just want to say, I certainly did not mean to suggest that we aren't in a crisis in this country with respect to what Trump is doing. I mean, I think DACA is another perfect example. Technically the courts have, allowed people to issue renewals, but you also have the administration going through deportations nonetheless. So I think there absolutely is a crisis, and it has human costs. I guess I just find some optimism in the way that the Constitution's structural aspects do thus far seem to be working in the abstract.
And as you all know, this is an NYU Brennan Center program, and I want to thank our panelists again. I have a couple more questions, and then I'm going to throw it to the audience. But Becca, Jameel, Elizabeth, Neal, Faiza, thank you all for being here.
Thank you.
Is this an anti-constitutional or unconstitutional aberration, ultimately? I had an encouraging conversation, mutual friend of Jameel's and mine, who said that he thought this was he didn't use those words, but in effect, this was a nightmare we were going to wake up from, and I think Jameel has highlighted the need for literacy and certainly a renewed empathy and understanding a lot of the situations, the stories here. But ultimately, is this going to be an unconstitutional aberration? Are we going to get back on course, Becca?
I mean, I was going to say this partially in response to the previous question, but it works with this one too. Like, I mean, you only wake up when you're out of it if you've slept your way through it. So I think that the only way that we wake up on the other side of this is if we fight like hell. And I think that, you know, litigation is one strategy in the toolbox. Lawyering in the law is one strategy in the toolbox. It happens to be the topic of our discussion tonight, but like the response to the first iteration of the Muslim ban was so powerful because it combined social movements, traditional protesting, people showing up at airports with a lawsuit, and a bunch of individual lawyers filing habeas petitions for people who were being held basically in black sites that they had turned airports into. So I think everyone, like, even if you're a lawyer, you need to recognize that you're taking an interdisciplinary approach. Another thing that I've been thinking about a lot is that resistance is by definition losing. Because if you're winning, you're not in the resistance anymore, right? You're the controlling power. And I think I can vouch for at least 3 of us, and I imagine all 5 of us sitting up here, that we're pretty ambitious, competitive people, and we don't like losing. But that, as Jameel can attest to in the national security cases, like, sometimes you bring these cases just because someone has to say that it's not okay. And I think that part of what gets us through this isn't going to depend so much on whether we win in court at the end of the day, but whether we like bothered to get up and say, this is wrong, this isn't okay, that regardless of whether I think the Constitution is like a dead essay or a tree or whatever other metaphor I want to use, that it exists, right? And that it's important and that we don't stop talking about it. So I think what is troubling to me but simultaneously makes me optimistic is like people who are like, oh my gosh, it's been a year and I'm so burned out. You do not get to be burnt out yet. We have a minimum of like 2.5 or 3 years to go, and what's going to make us wake up on the other side is if we fought our way through this side.
Right. Well, I just have one final question, and Neal, I hate to pick on you, but you were, for those of us who don't know, responsible in part for the special counsel provisions, what govern Bob Mueller's investigation. You know, ultimately, if Mueller were to be fired, there would be an obstruction argument quite immediately, but I'm wondering if you rely upon those provisions in thinking about the unconstitutionality of that possible act of firing the special counsel.
Yeah, so when I was 27, my first job at the Justice Department was to write those special counsel regulations. So it's just
I wasn't born yet.
It's kind of a weird thing, but sure, we thought about, could the special counsel be fired by the president? That was an obvious reality. We were replacing the Independent Counsel Act with something. This was a unique moment in time. It was 1998 and 1999. Right, the Starr investigation was going on, Whitewater and Lewinsky, and yet we'd also had Iran-Contra a few years before. And so there's a bipartisan consensus that the Independent Counsel Act had to go. Now, one part of the Independent Counsel Act did insulate the independent counsel from removal by the president. It said you could only remove for good cause. And I think there was a bipartisan consensus that that wasn't right, that you wanted to concentrate accountability in the president, that that's the structure of the executive branch, and that he'd have to take the heat. And that's, after all, what happened with Nixon. Nixon fires a special prosecutor, and that ultimately triggers the Watergate crisis and the ultimate removal of the president. Here, I do think, and I think the regulations, reflect this, the idea that the president could fire the special counsel. He might have to go through a step. He might have to order the acting attorney general to do it. But I do think he has the power to do it under our Constitution. I do think that triggers a constitutional crisis and impeachment right away, as it should. I mean, you know, you're talking about Mueller, who's one of the most respected government servants ever, you know, decorated military hero, nominated by, you know, Republican and Democratic presidents alike to be FBI director. The idea that you can't trust, okay, you know, you couldn't trust Comey, now you can't trust Mueller, you got to fire these people, is so antithetical to the rule of law. You know, I have to believe the Republicans will finally find their spine if he does this. And we all should fight like hell, because that will be the cover-up of all cover-ups. And he'll attempt it. It won't work in the end. The report's going to come out. There's state prosecutors involved. There's all sorts of avenues for Congress to get this information. It's not going to work. It might buy Trump a little more time, but that's all it will do, and will ultimately be his undoing.
On that encouraging note, questions, please. I'll keep going for a second. Mellon had suggested a lightning round, but I do have a question, and I understand if your current suits preclude you from answering. But along the lines of what Neal described, given the tenor and behavior of this administration, which does fire folks and then plays the victim card, to Becca's point, I mean, I think we shouldn't fail to remember the extent to which in the public discourse, the people who are making those decisions are making themselves out to be the victims, which is problematic in the situation that Neal describes. But now we have a line of questions. I was just going to ask you very directly.
They're all men. Some women need to ask questions.
So as the women assemble, this is the question. Will it take, you know, I do think there's some unsung credible Democratic nominees for president in 2020 who are not the names bandied about. But will it take, as it was for Richard Nixon, the president to be elected to a second term in order for impeachment and ultimately eviction from the White House to happen? Will it take a second term of unconstitutional behavior for the impeachment, the trial, the conviction, and do you think those things are going to come to fruition?
I don't think it necessitates a second term. I do think that what's important is voting in people, be it Republican or Democrat. I run a 501c3, so I feel like that's very important to say. But elect people who will take seriously the congressional role of oversight. Because, you know, to be honest, even just from an emolument standpoint, but then you add in everything that he has done since, you have more than enough right now to draft articles of impeachment. And, you know, once we have the report from Mueller and even more information, then I think we just need elected representatives in Congress who will take seriously their role, who will have the oversight hearings that are actually legitimate and interested in getting to the truth instead of just having a big political charade. But that can happen, you know, if people vote and register to vote and get out and vote in these next elections.
Thank you. Questions?
Hi, my name is Andrew Lindsay, and I actually work at the Brennan Center. So one thing that happened today while I was at work, we actually listened to a portion of the Martin Luther King speech, the final speech he made before being assassinated. And one thing I thought was interesting was that he invoked the language of like national brotherhood, right? Linking his movement to movements in South Africa. One thing that I thought hearing all of you all speak was thinking about some of the strategies that we could actually use to combat the false narrative that there is some sort of connection between nationality and criminality or terrorism. It seems to me that it's very difficult to use legal strategies to fill stopgaps to a policy that was actually made on the basis of animus, on irrationality. So I wanted to get a sense of that from you all, because this is something that I think will actually persist under future administrations as well. I don't know if this is an anomaly. because, I mean, we see the extreme vetting architecture coming out of the Obama administration as well. So I wanted to get your thoughts.
I mean, we're not just in a legal war, we're in a dialectical war, and we're losing pretty badly. I mean, I just think, like, how quickly has the phrase chain migration taken off and somehow become something negative, right? Like, you coming here and bringing your children and your spouse to join you now is somehow a bad thing. And that took like 140 characters, not including spaces. So I definitely think that it's, and you know, we all like to talk a lot, and we've been talking for like X amount of time, and you can't extract that many good talking points from any of this that will get a lot of salience in the way that people are getting their information. So I don't think that there's, I mean, I guess trying to make sure that Twitter remains an open environment is like potentially a legal strategy to address what you're talking about. But I definitely think that there have to be like discursive communication strategies that go with this as well, saying, hey, guess what? Your citizenship is an accident of birth that you had no control over. The reason you had to flee was probably a result of our foreign policy in the first place, and maybe we ought to do something about that.
And look at your wife and ex-wife, right?
Sorry?
In the case of Donald Trump. I mean, I think Jose Vargas responds quite immediately that a lot of people would be disqualified from being in the White House now if chain migration were banned or some form of it. Jameel, any thoughts on the bigotry and discourse?
Yeah, a lot of these policies are similar to policies that have been introduced in other countries, right? Even this the fake news idea, or this concept of fake news that President Trump has turned into one of his main rhetorical weapons is a tool that is used all the time by political leaders in Turkey and Poland and Egypt and India. Just today, there were reporters arrested in Egypt on the grounds that they had been publishing fake news. And I do think, in the United States, the human rights activists in the United States and human rights lawyers in the United States have, at least comparatively speaking, been relied on one another much more than relying on alliances with their fellow human rights lawyers in other countries. And now that we're facing such similar threats, I wonder whether we need stronger alliances with people who are doing the same kind of work that we're doing here in other countries.
Thank you for the question.
My name is Travis Morales. I'm with the group refusefascism.org. And I had a couple of questions. One or two people use the word authoritarian. And the question I want to pose is this. Given the fact that we have an administration, a regime that's moving to shred the rule of law, the separation of powers, the separation of church and state, criminalizing dissent, carrying out genocidal ethnic cleansing against immigrants, shouldn't we just call it what it is, fascist? And two, don't we have a responsibility to humanity before this demented bully with his finger on the nuclear trigger presses it, before they're able to carry out more wars for empire, and before they're able to consolidate a fascist regime in this country? Don't we need in our millions, because people are talking about it's very important what's going on in the courts, but don't we need millions and tens of millions of people in the streets to drive out this regime through nonviolent political protests like they did in South Korea before it's too late? Because from what I'm hearing from what's happening, it is getting close to being too late.
I mean, I think that the beauty of a democracy is that, or what it's supposed to be, is that everyone can respond to what's happening in office in a way that feels most appropriate to them, so long as it's within the confines of what is legal. And I'm not the free speech expert on this panel, but I would just suggest that anyone who's upset about what's going, like whenever someone asks me like, what can I do to help? My first question is like, well, what are you good at? Probably you can do that in some way that is helpful. So I think the answer is that everyone should be doing as much as they can in the way that makes them comfortable that at the end of the day they did everything they could.
I mean, I do feel, though, that sort of citizen mobilization is a big part of this, and we've certainly seen that, obviously the airports, the Women's March, I mean, there was an MLK march yesterday, I believe, as well in Washington. So we have seen this kind of mobilization. I feel like people are really kind of relying on the midterms, honestly, to some extent, and sort of hoping that there's going to be some change in that. And there's a lot of energy that's going towards, organizing and getting out the vote and pushing certain candidates. Again, 501c3, not endorsing anybody here, but pushing responsible candidates to the front. And there's a lot of energy and focus on that. I feel like that's a big part of it for a lot of people. And organizing is certainly going on, and there's so many ways to get involved in these issues. And I think that certainly people felt with the travel ban in particular that having that energy at the airports, having those demonstrations going on, day after day, did shape the environment in which those judicial decisions came out and was an important factor.
Since I'm the one who introduced the word authoritarianism, I feel like I should expand on what I meant by that.
I was trying to buy you time.
Yeah, well, so I don't think we live in authoritarian society. What I said and what I meant was that the policies that we've been talking about, the policies we've been challenging, reflect an authoritarian instinct. And I think that that's true of the travel ban, it's true of the Twitter ban, it's true of the emoluments case. I mean, all of these reflect a kind of authoritarian instinct. And the argument that the administration makes in these cases, that the courts lack the power to do anything about these violations, reflects an authoritarian instinct. So and the rhetorical attacks from the president on the institutions that are most important to our democracy reflect an authoritarian instinct. But we are not, we still have the ability to go to those institutions, to the courts, even to Congress, or at least to some members of Congress, and ask them to use the power that they have under the Constitution. That's what distinguishes us from our friends in Turkey or in Egypt. We still have the ability here to call on those institutions. But I think it's important to recognize the direction we're headed in, even if there's some distance between us and those other societies.
So Jameel is basically saying in short form, don't say fascist, say Russian.
Well, I don't know about that, but I would say, I fully echo the, President Obama's "Don't Boo" vote. I think that's incredibly important. But I think that, the Constitution, and this is the Constitution versus Trump, is an enduring document in part because each generation recommits itself to the Constitution's text and its values, and it is a reflection of something that has existed for a long time deep in our country, that we somehow elected an openly racist, misogynistic, xenophobic, happily corrupt individual as president. And so I do take while that was obviously deeply depressing, it wasn't necessarily anything that we didn't know about some parts of our country. And what is really inspiring to me is seeing the responses that have come forward, and especially the movements that are, we've had a lot of constitutional change because the people who were oppressed by those parts of our Constitution before they were changed demanded a change. And we have these movements led by folks who are demanding change. I think obviously we just saw the young folks in the gun regulations and concern about gun violence. We've had the Black Lives Matter movements, and also the young folks. I mean, I cannot tell you how deeply inspiring working with the DACA, with the Dreamers has been. I mean, these are folks who stand up and speak truth to power, even when it could get them, and it has gotten them detained and deported. So that gives me a lot of hope that there is some organizing that is responding to these terrible strains in our society.
We need to do what people in Germany didn't do in 1933.
Timothy Lunsford Stevens. I'm in Rise and Resist. I'm in the Immigration Working Group also, and I'm in Sanctuary and escort immigrants through the courts now to try to protect them a little bit. But I'm wondering
Thank you.
why there is not a lot of lawsuits to stop ICE in court when immigrants go to court in New York State, and we have a justice that supervises the New York courts, and she's not willing to stand up and say, ICE out of my courts. And I want to know what kind of lawsuits could be put to stop ICE in courts pulling immigrants that are there for criminal and civil cases out of this on the Constitution. And my second question is, when you're having your lawsuits, it's not just Trump. It's Stephen Miller and other people that are racist, fascist, whatever. Are you naming those individual people in your cases like Kelly and others that we don't even know about?
So just on the latter, we certainly name those who we can. So Stephen Miller didn't directly, he isn't directly responsible for the policy. He may have written it, so you can't name him, but certainly we name Sessions, we name the Homeland Security Secretary, and all of the, that cast of characters.
We named Dan Scavino, who is the president's social media director and used to be his golf caddy. I don't know, if the policy you're referring to is ICE picking up people in the courts, that seems like a good lawsuit to me. I don't know if anybody's brought it.
There's some iterations of it. I mean, so a lot of the state's attorneys general, Cardozo Law School's immigration clinic have brought variations of lawsuits about where ICE can pick people up and where they can't. And there's a lot of really good action happening at like the state and municipal level where mayors or governors can restrict access to things like hospitals.
But our mayor has said this is a sanctuary city, and we're not. And that's the big problem.
Okay, we have time for one more question.
Yes, hi. My name is Christopher Vicciola. I worked with President Obama's administration with the Syrian refugee crisis. I'm a member of Black Lives Matters also, and a political activist. My question to the panel is, do you feel, I should ask, why hasn't President Trump declared neo-Nazi parties to be a terrorist organization in this country? And also, why isn't there a ban against Russians? Mr. Mueller just carried out a sentence on a foreigner to be sentenced to 30 days in jail. I haven't heard Mr. Trump talk about that.
Well, he hasn't banned neo-Nazi parties for one simple reason. He believes they're very fine people. We've brought a lawsuit in Charlottesville basically to say, look, you guys neo-Nazis, you want to march? You can march. You just can't do it wearing an AK-47 and wearing military garb. You've got a right to do it, but you've got to do it in a certain way. And there are all these statutes that go all the way back to the founding of our Constitution in each state that prevent these people acting like fake militias and terrorizing people. So, I think the answer for why Trump is doing it is very clear, but that's, again, a way in which litigation can solve some of these problems. It can't solve them all, but it can do something.
And I would just add, contrary to naming them terrorists, the Sessions DOJ has actually pulled back on some of its monitoring of white supremacist organizations. And, the Sessions DOJ, we talked a lot about the Constitution versus Trump, but in so many ways, Jeff Sessions' Department of Justice is anything but. And that's just one example.
And again, now it's in reverse. So the folks who are critical of the DOJ are standing up for states' rights, California, and other states, and federal government's infringement upon states' environmental regulations.
Yeah, I mean, look, if Trump were to introduce some new regulatory, regime under which American organizations were labeled terrorist organizations and deprived of their rights by virtue of his labeling of them, I would probably be the first to challenge that policy. We've seen the way those kinds of processes have been used in other contexts. And the same with the other one. I'm actually a little bit uncomfortable with the debate that we now have around Russians, which is sort of expanded from Russian interference, official Russian interference in the American election, which is obviously a legitimate concern. And it has expanded to, in some cases, what I worry is a kind of xenophobia. And you know, I am as outraged as anybody about Trump's abuses, but we need to make sure that our responses to Trump's abuses are also consistent with the Constitution. We want to make sure that, you know, we are preserving the freedoms that we are worried that Trump is taking away. And, you know, I say that having litigated a lot of these issues under the Obama administration, where, you know, President Obama, often for very good reasons, introduced policies that were, you know, meant to protect national security, but whose consequences were, you know, very significant deprivation of rights on the part of people who had nothing to do with threatening national security. And, you know, I think we want to learn something from that. I don't mean to blame President Obama in particular. President Bush was even worse, you know, in that respect. But I think we should learn something from that history and be careful about how we respond to legitimate threats to national security now.
Becca, final thought?
Yeah, I mean, I think you probably raised the Russia ban as a rhetorical device as much as anything else, so I don't want to take it too literally, but I think I was going to make the same point as Jameel, which is that, like, we can't respond to the ban with another ban of people that we think are worse, right? Oprah can't be the next president, right? It doesn't solve the constitutional crisis to elect another like television celebrity personality to the office. So, like, just along the lines of making sure that our tactics and what we're calling for are sort of in line with our basic principles, I think that a lot is being done to rile up anti-constitutional, that's the C3 way of saying alt-right, forces. And that we need to fight that as hard as we can, but that as we do that, we need to make sure that our resistance, or whatever you want to call your action in response to it, also mirrors the values that you're trying to protect.
With that, please help me in thanking this panel. Thank you all for coming out tonight.